Welcome to the Prelude episode. This is an introduction to the podcast series UAE Crypto Litigation, a discussion of the book by Mahmoud Abuwasel, available at www.uaecryptolitigation.com.
Right. And today, our main goal really is to equip you with the mental roadmap for this whole series. So this deep dive, it's going to outline the book's origins, where it came from, its central theme, exactly what ground it covers, the scoop of the analysis. And maybe most importantly, we're going to introduce the systematic four-part analytical framework. This is really the engine of the research, and we'll be using it consistently in every deep dive that follows, basically to turn case law into practical, actionable knowledge for you.
Okay, sounds good. Let's maybe unpack this by starting with the author, Mahmoud Abuwasel. What I find fascinating is just how early his involvement began. We're talking consultations way back in, the second half of 2010, and then actually buying his first mining machine in 2013. But his day job, his core focus, has always been high-stakes international disputes. That kind of timeline really tells you his engagement with digital assets wasn't, theoretical. It was always about the friction points, the contentious side.
Precisely. And that deep immersion from both an operational and a legal angle, that's really the bedrock of the book. It's not some detached academic survey. The author puts it as being born from being in the trenches. I mean, his firm has been right in the thick of it, representing parties in major arbitrations against big crypto exchanges, dealing with complex IP fights over NFTs, litigating against unlicensed VASPs, virtual asset service providers, and handling really sophisticated cross-border fraud requiring detailed on-chain asset tracing. It's very hands-on.
Wow, yeah. That level of direct real-world exposure must have really highlighted some gaps, I imagine. Maybe a big problem for the industry.
It absolutely did. Despite the UAE rapidly emerging as this global hub for digital assets, there's a noticeable gap, a real lacuna in systematic analysis. Specifically looking at the contentious side of things. How does the established UAE court system actually systematically apply its laws when these new digital asset transactions go wrong? Addressing that gap, providing that clarity, that was the core motivation behind putting together this comprehensive work.
Okay, so if the courts were tackling these disputes before we had the really detailed regulatory frameworks we see now, before Viero, before the SCA had their full rule books out, how did they actually decide these cases? Was there some kind of unifying principle that emerged from those early rulings?
Yes, there was. And this is probably the single most important takeaway from the entire book. It's a principle we're calling judicial pragmatism. What we saw consistently was that even when there wasn't specific, detailed crypto legislation for the period in question, the courts didn't get sidetracked. They consciously looked past the, let's say, high-tech novelty of it all.
Okay, wait. Isn't that a bit risky, though? I mean, if they sort of ignore the technology, the specifics of blockchain, smart contracts, token features, aren't they potentially missing critical technical details? How did they manage that without overlooking risk?
That's a great question, and it gets to the heart of the insight. They didn't ignore the tech existed, but they minimized its, let's say, doctrinal importance. So instead of getting bogged down trying to definitively label a token, is it a security, a commodity, a currency, which frankly paralyzes progress in many places. They focused intently on the core economic substance of the deal and the actual intent of the parties involved.
Right. Could you maybe give an example? How did that pragmatism actually work on the ground?
Sure. Let's say you have a dispute over an undocumented Bitcoin transfer done over the counter, OTC. The court wouldn't kick things off by analyzing Bitcoin's proof of work or anything like that. Instead, it would ask really fundamental questions. Was this transfer intended as a loan? Was there a clear expectation of repayment? Or maybe it was a capital contribution to some kind of partnership? Or was it purely speculative, where the person receiving the Bitcoin clearly understood they were bearing all the risk?
I see. So they effectively applied well-established legal principles, commercial law, civil law, sometimes criminal law principles that have governed complex trade for, decades. They just applied those to the new digital facts. That must have provided a significant amount of clarity and predictability for people operating in the market, even if the specific crypto rulebook wasn't fully fleshed out yet.
Exactly. That methodical approach, applying foundational law to new fact patterns, is what delivered legal certainty. Now, to really appreciate where this analysis comes from, we have to be very precise about the scope. Context is vital here.
Okay, let's nail down the jurisdiction then. The book draws on, over 100 judgments? But it's quite specific in its focus, right?
It's extremely specific. It focuses exclusively on the UAE's onshore civil law courts. That means the courts of first instance, appeal, and cassation across the different Emirates, Dubai, Abu Dhabi, Ras Al Khaimah, and so on. And crucially, the analysis deliberately excludes the financial free zones, the DIFC, Dubai International Financial Center, and the ADGM, Abu Dhabi Global Market.
Why is that exclusion so important for listeners to grasp? What's the key difference?
It really comes down to two fundamentally different legal traditions operating side by side. The DIFC and ADGM are common law jurisdictions. They operate largely in English, have their own distinct court systems, and rely heavily on binding precedent, the doctrine of stare decisis. The onshore courts, however, operate firmly within the civil law tradition. Codified written laws are the primary source of authority, and the language of the court is Arabic. By concentrating solely on the onshore civil system, the book offers guidance relevant to the vast majority of businesses and individuals operating across the wider UAE.
Okay, that definitely clarifies the landscape. And speaking of the civil law tradition, you often hear that precedent isn't strictly binding in the same way as common law. Is there a nuance there in the UAE system that, say, a litigator really needs to understand?
Yes, that's an important nuance. While it's true that stare decisis as a general rule doesn't apply, meaning a lower court isn't automatically bound by every single prior decision from another court at the same or lower level. Principles established by two key judicial bodies are considered binding on the lower courts within their respective hierarchies. First, the Federal Supreme Court at the federal level. Second, the General Assembly of an individual Emirates Court of Cassation, like the Dubai Court of Cassation's General Assembly. When those bodies lay down a legal principle, lower courts are expected to follow it. So understanding which court level issued a judgment is absolutely essential for gauging its weight, whether it's merely persuasive or actually binding.
That's a really helpful piece of context. Okay, now let's shift gears and look at how the book actually organizes all this dense material. It uses this concept of the 7-part life cycle of a dispute.
Right, and the organization is designed to be highly practical. It essentially mirrors how a commercial relationship typically progresses from the initial setup through potential breakdown and then into enforcement. This structure gives the book a kind of dual utility. You can read it straight through, cover to cover, to get the full narrative arc of how the judiciary has responded over time. Or, perhaps more likely for busy professionals, you can use it as a modular reference guide. Just jump straight to the section dealing with this specific challenge you're facing right now.
Let's give listeners a feel for that. Maybe we can highlight a few key phases from that life cycle, focusing on some of the trickier.
Absolutely. Let's start right at the beginning, part 1, foundational principles and characterization. This is often the make or break step, the one that really sets the direction for the whole dispute. For example, if an agreement isn't crystal clear, the court has to characterize the relationship. Was that transfer of crypto meant to establish a custodian or deposit relationship which brings specific duties of care? Or was it just a straightforward purchase agreement? How the court characterizes it dictates which laws apply, who bears the risk, everything. It's fundamental.
And then, inevitably, relationships sometimes break down. So the book moves into that reality in part 3, covering disputes, fraud, and illicit schemes.
Exactly. This is where the analysis gets into the messy reality of commercial breakdown. It involves dissecting complex situations like how courts picked apart Ponzi schemes that used crypto hype as a lure, or figuring out which contracts are simply void because they involved an unlicensed fee ASP, making the whole deal illicit under the law at the time or even now.
Part 5 sounds particularly crucial, especially in crypto. Enforcement, remedies, and recovery. Getting a judgment is one thing, but actually getting your digital assets back, that can be the real challenge.
It really is, often because assets might be decentralized, held offshore, or difficult to access. So this section dives into the court's willingness, for instance, to grant orders for specific performance, meaning compelling the return of the actual crypto assets in specie, not just their cash equivalent. That's vital when dealing with volatile assets. It also maps out the often complicated process for recovering funds that might have been seized or frozen by law enforcement during parallel criminal investigations.
And finally, Part 7 tackles something often decisive in these cases, the link between civil claims and criminal proceedings, specialized topics, and interplay with criminal law.
Yes, that interplay is absolutely key in the UAE context. The book examines how a final criminal conviction, say, for fraud or money laundering related to the crypto transaction can act as powerful, sometimes even conclusive, evidence in a follow-on civil claim seeking restitution. And conversely, it looks at how a criminal acquittal might influence, though not necessarily stop, a parallel civil case seeking recovery of assets or damages.
Okay, so that 7-part life cycle provides the structure, the backbone. But the real engine, the thing that makes this a deep dive and not just, say, a summary that's the standardized methodology applied to each case study. Let's really dig into that four-part analytical framework.
Right. This framework is the absolute core methodology for the book and consequently for this entire series. It's the mechanism that transforms a historical court judgment into a practical, usable roadmap for professionals operating today. Maybe let's use a quick hypothetical to illustrate. Imagine a major crypto exchange gets sued successfully because a security breach allowed a hacker to steal a large amount of client assets.
Okay, so the first step in the framework is always setting the scene.
Exactly. Step one is the legal problem. We frame the specific legal or commercial question in its real-world context. So in our exchange hypothetical, what precise duty of care does an exchange owe its clients when it holds their digital assets? Does the law view it like a bank deposit demanding almost absolute security? Or is it more like a standard commercial agreement requiring just reasonable care? Framing that question defines the whole liability issue.
Then step two gets into the actual court decision, judicial analysis.
This is where we do a really granular breakdown of a key UAE court judgment, ideally from a high court like Cassation that directly tackled that specific duty of care question. We dissect the court's reasoning. Did the judge hold the exchange liable based on the fine print and the terms and conditions, or was it based on broader principles of civil liability, like tort? Understanding how the court arrived at its conclusion, especially regarding causation, is critical.
Now, many of these key judgments happened before the current, very detailed crypto regulations were in place. So the third part brings it up to date. Regulatory considerations.
Absolutely essential for anyone thinking about compliance today. We take that same basic scenario, the exchange losing client funds, and we assess it against the current regulatory landscape. We look at the relevant rules from the SCA, Securities and Commodities Authority, the CBUAE, Central Bank of the UAE, or perhaps Dubai's VARA, Virtual Assets Regulatory Authority. The purpose here is to show how, for example, VARA's specific rules on digital asset custody, cold storage requirements, or mandatory security protocols might now preempt or significantly alter the reasoning seen in that older judgment.
That contrast seems incredibly valuable. You see the gaps the court had to fill using general legal principles, and then you see the specific regulations designed to prevent that same ambiguity going forward.
And that flows logically into the final and arguably most practical step: contractual risk mitigation and transactional architecture. This is where we shift from looking backward at the case to looking forward, focusing on prevention.
So applying it to our hypothetical exchange breach, what's the actionable advice?
We translate the lessons learned, the failure points identified in the judgment, into concrete commercial guidance. If the exchange in the case lost partly because its terms and conditions were vague about liability for hacks, then this section recommends the specific, robust clauses that should be included in VASP contracts today. We pinpoint the structural weaknesses, the operational gaps, the evidentiary failures, maybe a lack of audited security protocols, unclear position on insurance, fuzzy key management procedures that contributed to the dispute. The goal is to guide you on building more resilient legal structures and processes to minimize that ambiguity from the start.
Right, it's essentially turning a legal postmortem into a preemptive defense strategy for businesses.
Precisely. You know, the analysis of these 100-plus judgments, it largely captures an era of what you might call ex-post judicial resolution, the courts dealing with the consequences after something went wrong.
And the rollout of these comprehensive VASP regulatory frameworks by bodies like VARA, SCA, CBUAE that really signals a major shift towards ex-ante regulatory compliance. Prevention first.
That's the fundamental shift. Going forward, disputes are increasingly likely to center on interpreting and applying those very specific granular rulebooks rather than debating foundational legal characterizations from scratch. But, and this is key, the underlying methodology we've established here, the approach of connecting historical case law, current regulations, and forward-thinking contractual design, that remains absolutely essential.
Especially, I'd imagine, as the technology itself continues to evolve so rapidly. We're already grappling with complex new areas like decentralized finance, DeFi, DAOs, real-world asset tokenization. These create entirely new jurisdictional and liability puzzles. The ability to anchor these novel structures and establish commercial principles the way the UAE courts have consistently demonstrated, that seems like it will be critical moving forward.
Absolutely. Those foundational principles, legal certainty, the importance of clear evidence, the orderly allocation of risk and liability principles powerfully illustrated throughout these judgments, they remain the constant anchors, regardless of the specific technology involved.
That brings us to the end of the Prelude episode. The structure we've outlined today is the standard methodology used throughout the book and this series.
Authored by Mahmoud Abuwasel and drawing on analysis from over 100 judgments, UAE Crypto Litigation serves as an indispensable resource for those in the digital asset industry.
To explore the complete 7-part life cycle of a commercial dispute covered in the book, please visit www.uaecryptolitigation.com. Join us weekly for new episodes after the book launch.
The discussion in this podcast is for educational and informational purposes only and does not constitute professional advice. Accessing this content does not establish any other professional relationship. Please consult with a qualified professional for advice tailored to your specific situation.